Hi everyone, I wanted to discuss important case laws which deal with subsistence of copyright. And we saw that subsistence of copyright is dealt with in section 13 of the Copyright Act. So, without wasting any time, we'll see that section 13 gives copyright protection to original literary, dramatic, musical artwork. So we need to understand what does the word original mean here. And we see that the first case is Northrop Limited versus Texty Blackburn Limited 1974, in which it was said that the expression should be original. As we have discussed earlier, there is a very famous idea expression dichotomy that persists in copyright law, and copyright gives protection to the expression and not to idea, and hence the expression part should be original. Next, we deal with the case of Interlego versus Tycho, in which it was said that any work that is created should be more than a slavish copy. Here, slavish refers to putting labor like efforts into creating something. So, if you have a book in front of you, for example, Harry Potter's book, and you are creating a copy of it, like in a unique manner, you have changed the chapters, but you are making a copy of that, it will not give you any protection. The third case is Perry versus Moring, in which plaintiff copied private letters of Sir William and translated them into English and arranged them in an order. So in this case, he is copying the private letters, but then he is translating them and arranging them in a particular order, and hence copyright was given to such work. It was held to be original literary work because he has applied labor, skill, and judgment to come up with the end result. Next, we have the case of University of London Press versus University Tutorial Press Limited. This case we have discussed in the previous lectures also. It concerns two professors from different institutes creating a mathematical paper which were claimed to be identical, and one said that it is infringing upon the other's copyright. However, it was said that question papers are original literary work of both the individual professors. So the important point out of this case was that question papers are also given protection, copyright protection, because the professor who has created it has again put use of his labor, skill, and judgment into creating that work. Next, we have the case of V Ramaya versus V Lakshmaya. In this case, a guidebook. So you have a main NCRT book, and then there is a guidebook that people usually refer to, which explains similar concepts with further examples and more easy language. So this guidebook is also given equal reputation of original literary work. Next, we have the case of Eastern Book Company versus DB Modak. This is a landmark case, and in this case, the Supreme Court moved away from sweat of the brow doctrine. In this case, copyright was claimed in compilation, where author must exercise skill and judgment, which may not be creative like its novel, non-obvious, but at same time it is not a product of mere skill and labor. Work must have flavor of originality to be original. Here we see adoption of minimum of creativity test, or also known as modicum of creativity. As we were seeing above, that labor, skill, and judgment is applied. So in this judgment, Supreme Court held that merely if you have applied skill and labor will not give you sufficient creativity to your name so that you can claim the work is original and get copyright out of it. You have to add a slight creativity such that a flavor of originality is there, and then again it is subjective, as there is no definition to it, or there is no further explanation to what will bring this flavor of originality. Next, we come to the topic of idea expression dichotomy that we also dealt with earlier, and one of the cases is Bharat Matrimony Private Limited versus People Interactive Private Limited. In this case, plaintiff sought copyright in IVR system. IVR is Interactive Voice Response System. What it basically does is, like when you are calling to Amazon or Myntra, you get connected to their voice system, wherein it gives you certain options, like if you want to talk in Hindi, press 1, if you want to talk in English, press 2, and then if you're concern is regarding return order or placing new order or tracking where your order is. That is what IVR system is, and the plaintiff sought copyright in this system. However, court held that this is an idea, and over it no copyright could be given, because IVR system is heavily used by banking, railways and your shopping websites, and no monopoly could be given to one which is against the objective of copyright, right? The purpose is not to give monopoly to one person. So next we have the case of Denog versus Allied newspaper, and it is a very landmark case that you must know. In this case, what happened was, Denog, here D is representing Denog. He was a well-known jockey and he communicated his adventures with a freelance journalist. The journalist used to make notes during the conversation and he used to get it reviewed with Denog, and they used to make some corrections if there were any, and he published those articles with necessary alterations. And it was at the behest of this journalist only that all the original articles that were published came as a fresh compiled article, in which Dunok claimed that there is an infringement, and therefore he sought injunction restraining this publication. However, Justice Farwell held that Dunok did not have any copyright, as the adventures were communicated to public in the language of journalists and not Dunok. So this is quite controversial, right? He's saying ki I accept that Denog, it is your story, but it is being communicated to the public in the language of the journalist, and hence he will have a copyright over this. And this critique was highlighted by Justice B.N. Kirpal in the case of Najma Heptullah versus Messrs. Orient Longman Limited. And Justice Kirpal noted that if reasoning in Dunok's case is correct, then it means material on the basis of which literary book is written is irrelevant. Examples: great scientists may not have literary capabilities to communicate their idea, and then they might hire another person to communicate that idea, and then you are saying if the person who is writing gets the copyright, will take away the right of the scientist who has come up with the entire idea. It is also possible that the person who's communicating the idea is not even understanding what he is writing, right? So how can you give copyright to the person who's just writing? So he uh, further says, I'm quoting here, to me it appears that if there is intellectual contribution by two or more persons pursuant to a preconcerted joint design to the composition of a literary work, then those persons have to be regarded as joint authors. So here he says that if two people are contributing, then both should be joint authors. It is crucial to note that in the case of Denog versus Allied newspaper, Denog did not try to claim for joint authorship. He was saying it is my work only. By the way, this case of Najma Heptullah versus Orient Longman pertains to the case of Maulana Azad's autobiography, which was written by Professor Kabir. And similar facts are there, like he used to narrate his story, Professor Kabir used to write it down, get it reviewed, and then they both sat through the reiterations, and finally the work was published. Here it was noted that the work India Wins Freedom is a joint effort, is a collaborated work, and both are joint authors in this work. Next we have the case of R.G. Anand versus Deluxe Films. It is a landmark case in the idea expression dichotomy. The facts briefly are that the plaintiff is a playwright, dramatist, and producer of stage play, and he wrote a play called Hum Hindustani based on idea of provincialism and parochialism. Back facts are like he thought that this work is capable of getting converted into a movie, so he went to the defendant and showed him the script that this is what I have in mind. But that conversation never actually materialized into something fruitful. However, plaintiff got to know that defendant has made a film which was titled New Delhi, and it portrayed the three themes, like two aspects of provincialism with respect to marriage and renting out place, evils of caste-ridden society, evils of dowry. So he said that this is a infringement of his work which he took to him. However, Supreme Court laid down following propositions to ascertain whether two works are similar and infringing on one's copyright. So it was first said that copyright does not exist in an idea, right? Subject matter, themes, plots, or historical or legendary facts cannot be ground to claims copyright on. Second, in order to be actionable, copy must be substantial and material one. So substantial copy होनी चाहिए, materially बहुत similar होना चाहिए काम, in order to claim that there is copyright infringement, which at once leads to conclusion that defendant is guilty of an act of piracy. When you say which at once, it means कि देखते ही पता चल जाना चाहिए कि काम A is a copy of काम B. Okay, so next is that one of the surest and safest test to determine whether copyright violation exists is to see if the viewer reader of both the works is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be copy of original. Like recently you would have seen the trailer of Fighter movie, and the instant I saw it, I was like, this is a copy of Top Gun Maverick without thinking. So this is what unmistakable impression that the trailer left. Next, where theme is same but expression is different, then there is no copyright, because we saw that copyright only exists in expression, right? So where despite few similarities, broad dissimilarities exist, which so it negates the intention to copy and hence the work is original. Next, court noted that plaintiff has to prove piracy to claim copyright infringement, which is different as it manifests its nature of stage play to be short, but films are longer and entail wider perspectives. So court here noted that by default nature of play and film is different. So if the defendant is if you're saying defendant is copying the work, it is not possible, because he has to run a longer duration of film which has to cover with multiple things to express the storyline. Hence it was held that there is no copyright infringement. And here we can make reference to a US case of Nichols versus Universal Pictures Corporation, where the Nichols abstraction test was given, and it speaks on the line of that if two works are present and you think whether copyright infringement exists or not, so you identify the substantial portion of the work and take away the not so substantial part and see whether that substantial part is similar to each other. If it is, then it would amount to breach. Next, we deal with the case of Barbara Taylor Bradford versus Sahara Media Entertainment. This case is only important with respect to the ratio it had given. It is a Calcutta High Court case from 2004. So this case explained rationale behind basic copyright law. That is, you can borrow the idea of another author but not the expression, right? So if you like the idea of J.K. Rowling's Harry Potter, you can copy that idea. There is no harm in copying the idea of a wizard boy who's left orphan and he's fighting against evil people, but you have to give it a different expression. You cannot copy it word to word or novel to novel. Next, court noted that there are certain plots and ordinary prototype characters. So the word here is used, prototype character, that will be present in every most of the dramas that are coming. Like if you are a big K-drama fan like I am, you'll notice that there is this very poor girl who's protected by the rich CEO guy who comes into her life, and she's a stepdaughter or is living with some relatives who are very mean to her. So her life is very miserable and everything. So these are some prototype characters that are used by everyone. So one drama cannot go and claim infringement of copyright on the other, right? So law of copyright was intended at granting protection and not intended for stopping all literary work altogether by its application. So how to determine whether it's a copy of idea or expression? This is the most amazing part of this judgment that I like. The best answer is that there are no final answers yet, and there is no hope that there will be any final answers ever. These are situations of legal assessment, and that's like a plus plus for the lawyers, because our job is to analyze the law and twist and turn it to be favorable towards the need of our clients. So what are we fighting for? Next is the case of Harman Pictures NV versus Osborne. In this case, it was said one must not conclude that copyright infringement has occurred merely because of similarity between stock characters. So here we are seeing stock character is the word that I wanted to highlight earlier. It was prototype character are present, prototype plots are present. So just because it is same in two works, it does not by default mean that there is copying of work, right? Next, there is this concept of idea concept dichotomy in confidential agreements, as we were seeing the case of RG Deluxe. In this case, the person went to the playwright went to the producer, RJ Anand versus Deluxe Films. My bad. In this case, the playwright went to the producer to have his play converted into a film, and he communicated the entire script in good faith. And a lot of time it happens that you have an idea and you go to the person, but they don't include you in the execution of the work. So what protection do you have in this circumstance? So usually you can get uh, confidentiality agreement in place to have your interests protected, and we have a few cases to discuss on this line. First is Anil Gupta versus Kunal Das Gupta. In this case, plaintiff shared concept note to defendant under strict confidential agreement of a TV program called Swayamvar, where woman herself will select a groom. Defendant planned on launching the program without plaintiff, who filed for copyright infringement. Court noted idea per se has no copyright, but if idea is developed into a concept note, like concept note is more than the idea, like you have written down this will be the character, or this is how it will go on, episodes will be bifurcated into this, and we'll play this game, or we'll have these criteria to select the men, then you have developed into a concept fleshed with adequate details are present, and it is capable of copyright protection. Next is Urmi Juvekar versus Global Broadcast News Limited. Here, what happened? We are just taking the ratio to ascertain whether substantial reproduction has taken place. Court applied the average viewers test. That is, two works are not to be compared with hypercritical and meticulous scrutiny, but from the standpoint of observation and impressions of an average viewer. We have seen it in the earlier cases also. Like, if you want to ascertain, the surest and safest way to ascertain if two works are similar is to see if a viewer who is dealing with the content finds it to be similar. Next is the case of Mattel Incorporation versus Jayant Agarwal. In this case, the doctrine of merger was applied. Doctrine of merger by default says that you don't know where idea ends and expression begins. It's very difficult to separate the two, and in this case, no copyright will be given. So what happened here was plaintiff claimed copyright in their word board game Scrabbles. It was alleged that defendant came up with a similar web-based game using identical color tiles, patterns and arrangements of color tiles, and use of star pattern on central square. So look-wise everything is same, only the medium of putting the game of Scrabbles across has changed. So defendant relied on the doctrine of merger, that there is no copyright in the alleged elements in the games because they are part of playing a game. They are rules of a game and they cannot be distinguished from the expression of a game, and hence an idea in game would be given monopoly otherwise if it is allowed. So such a result is not intended by lawmakers who only wanted expression of idea to be protected, and hence games become a major spot point for application of this doctrine, and it is difficult to get copyright for such things. Next is the case of Indian Express Newspaper Private Limited versus Jagmohan Bombay High Court. This is a very interesting case personally for me. So in the case of RJ Anand versus Deluxe Film, it was held that actual events cannot form basis for copyrightability. Okay, and this rationale was blindly followed by Bombay High Court in this case, where what happened was there was one Mr. Sareen. He was an investigative journalist with Indian Express, and he took it upon himself to expose the flesh trade happening in Madhya Pradesh, and he integrally took part in doing this undercover operation. Like, he got involved with flesh trade and he published several reports to bring the illegal trade to light, and on the basis of the report that Mr. Sareen had come up with, there was a well-known playwright, Vijay Tendulkar, who came up with a play and then a story for a film. Now, this journalist and newspaper proprietor claimed copyright infringement, and however, it was held here that there is distinction between materials upon which one claiming copyright has worked and the product of application of his skill, labor, judgment, and literary talent to these materials. So he's saying that the work is an actual event that is already there. However, to create a story, a play out of it for a film, required a lot of skill, labor, judgment on part of Dr. Jagmohan, and hence there would be no copyright infringement on his part. So the form, manner, or arrangement of a drama, movie are materially different from newspaper articles, and by nature of media has substantial dissimilarity. So this judgment failed to understand that in this case Mr. Sareen put himself in danger. He was like doing an undercover operation to dig out the facts. He used his intellect to get this information out. However, the producer unjustly enriched himself at the cost of the journalist, as this information not really explicitly in public domain. It was something he took out and he did not get due recognition for the same, which is sad. So we have discussed all these cases. I hope it will be useful for you. I'll bring out another section to deal with specific cases in literary work, dramatic work, artistic work, and musical work. Right. Thank you.